You know, it's always a little bit disconcerting when my name is announced and people start leaving the room like this. But I'm going to assume it's the time of day rather than my presence. But it's my great pleasure to welcome you to the final session today on designing a legal framework for unified ledgers. We've had some fascinating discussions so far in this conference on the potential for tokenization to really shape the financial system of tomorrow. And all of this is relevant for the vision of unified ledgers and the Finternet laid out by Augustin Carstens in his opening remarks. The unified ledgers concept envisages a world in which tokenized central bank money, tokenized commercial bank deposits, and other types of tokenized assets would coexist on the same platform or platforms in a way that would enable programmability, composability, and automation. As my colleague Morten Beck has just explained, our new project, Agora, I hope I pronounced that correctly, explores some of the key features of the potential for unified ledgers. Two key projects in the United States and South Korea, respectively, have explored or are exploring some elements of the vision laid out by Augustin Carstens this morning. In the US, our friends at the New York Innovation Center, in collaboration with members of the US financial services industry, have participated in a proof of concept that experimented with the idea of a regulated liability network, or RLN. And the RLN concept envisages theoretical payment infrastructure designed to support the exchange and settlement of digital representations of central bank money and commercial bank deposit tokens using distributed ledger technology. And in Korea, the Bank of Korea has announced a joint project with the Korean regulators under which wholesale CBDC issued by the central bank will coexist on the same platform with tokenized commercial bank deposits and CBDC-backed tokenized e-money issued by financial institutions. While there are many different issues that need to be addressed in bringing the unified ledger into reality, one should not underestimate the importance of the legal framework. And indeed, Augustin Carstens in his opening remarks, and many of our panelists today, have stressed the importance of a legal framework to ensure that the unified ledger would actually work. I think, as is the case with almost everything in life, it will only work if the law is there to support it. We're privileged to have with us today two distinguished lawyers who played key roles in the two projects I just described, and who will share with us some of the key legal issues that arose in these projects in a way that will help inform our discussions on the design of a legal framework for unified ledgers. It's my great pleasure to introduce to my immediate left, Ms. Rebecca Simmons, who is a partner in Sullivan and Cromwell's Financial Services and Capital Markets Groups in New York. Rebecca is head of the firm's payments practice and co-head of its fintech practice, and her practice focuses on financial services functions such as payment, clearing and settlement, and the development of new approaches to financial services operations, including the use of new technologies. And Rebecca was the principal author of the 2023 legal report on the regulated liability network proof of concept. To my far left is Dr. Jong-Goo, who is a senior partner at Kim & Chang, the largest law firm in Korea. He's a member of the Regulatory Reform Committee of Korea's Financial Services Commission, as well as a member of the Money and Banking Forum within the Bank of Korea, where he advises on central bank digital currencies and digital asset issues. Dr. Yi has a PhD in economics from Stanford University and a JD from Stanford Law School. So Rebecca and JG, welcome. So we have 40 minutes for this session. And what I would like to do is to pose 3 questions to our panelists and give them each the opportunity to respond. And after that, we should have some time left at the end for some questions from the audience. So I'd like to start by asking each of you, starting with you, Rebecca, to briefly describe in somewhat more detail than I just did the principal features of the project that you were involved in, and then perhaps to lay out what you consider to be the key, I guess, most challenging legal issues that would need to be addressed for the model that formed the subject of the project to actually work. So, Rebecca.
Well, thank you very much, Ross, for having me and for the kind introduction. I'm actually not sure I was the principal author of the report, but I was the coordinating author of the report. We had a working group of many lawyers, both internal and external, who were major contributors to the report, including my colleagues. So, but I think RLN works in many ways similarly to what the ways in which Agora would work. I think our diagram looks similar, but not quite the same. We provide, the project contemplates that you will have a payment between an originator and a beneficiary, as you would today, and then settlement of the resulting liabilities amongst the different banks in the payment chain, as you would today. But those are two sort of separate lines of settlement, but the RLN system would ensure that both of those settlements occur simultaneously by using both central bank tokens and commercial bank tokens for purposes of achieving simultaneous settlement of all the steps in the transaction at both levels of the payment, or none of them at all. So it either all happens or none of it happens. I think we did use deposit tokens, or we refer to deposit tokens in a wholesale CBDC in the report, but I think one might argue that the tokens were not in fact deposit tokens or a CBDC at all, because they have a very limited life and a limited purpose. The system uses them to reflect the money as it, sort of moves up to the edge of the division between the paying bank and the next bank in the chain, but no token ever actually moves from one holder to another. They all stay within the partition of the bank that issued the token. And then in the proof of concept, we assume they disappeared or were burned, but that wouldn't necessarily be the case. They would just go back. They could just go back into a treasury, to be used in the next transaction. We started out with the design questions around this system. Actually, the very first question that we started looking at was, what is the legal nature of those tokens, and what is how should they be characterized? You may be aware that tokens in the United States have a somewhat fraught situation at the moment. It would not be beneficial to a system if you had to deal with these being tokens that could be characterized as securities, commodities, or something else that could subject a system using the tokens to a whole level of regulatory constraint that actually might make it very difficult to create a functioning payment system. But fortunately, there was no need to worry about that. These tokens are not being used in any way that implicates any of those regulatory frameworks. So one of the very first decisions we made was between sort of, just express it as two extreme models. In one model, you have a system where the token itself embodies a deposit. The transfer of the token or the ownership of the token is enough to evidence ownership of an underlying deposit. So that would be like an old cashier's check or a banknote. That is one approach you could take to these kinds of a system. The other end of the extreme could be a system where the token exists and is used to carry out the mechanics of updating the ledger, but has no independent significance. And RLN is closer to that second model. That was driven largely, of course, by the way the system was going to work, and the technology and the goals of carrying out the payment were obviously the driving factor, and the legal analysis has to accommodate that. But I think it was also helpful to the legal analysis because it allowed us to rely for the next big issue on Article 4A of the Uniform Commercial Code. So the second big issue that we were dealing with was settlement finality. Could we get to the point where we could be confident that payments made through this system would have at least the same degree of finality than payments made through traditional payment systems today? Of course, we did come to that conclusion. And one of the important pieces of that conclusion had to do with making sure that we could control for finality, at least insofar as US law is concerned, at all steps along the way, including those steps that occur out with banks located outside the United States. That choice of law issue is a challenging question in any context, but at least if you're subject to Article 4A of the UCC, you can rely on the choice of New York law or whatever state law ends up governing the system to govern the entire payment chain from beginning to end, which is important when you want to know that everybody is going to achieve finality at exactly the same moment. So obviously settlement finality was another major point. And I guess the third major point, there were other things that we had to look at, but the third major point would have been the regulatory status of the parties involved in operating the system. There's obviously the participants in the system who would not want to be subject to a new regulatory framework simply by making a payment, any more than you would be today by virtue of making a payment through FedWire or CHIPS. You already have to be regulated, but you don't have a new regulatory requirement as a result of that. And then there's the system operator, the entity that handles the operation of the ledger on which all these transactions are taking place. That entity, we think, would constitute a financial market infrastructure or a financial market utility, as we call them in the US. But unlike other jurisdictions, the mere fact that you are a financial market utility does not mean you are subject to an enhanced regulatory framework. We have something of a backward system in the sense that we have a very good and very functional regulatory framework for systemically important financial market infrastructures. In the case of payment systems, that's operated by the Federal Reserve. But that only applies if you have been designated as a systemically important financial market infrastructure. And of course, you have to become significant to then be designated and then be subject to that framework. The statute actually has some flexibility, but it's never been exercised in that way. So there is clearly a payments framework for payments generally in the United States, but unlike, for example, the European framework, it doesn't provide special protection for settlement finality. It doesn't provide for enhanced supervision unless and until you are designated. And even if you are designated, you don't get special protections for your finality of payments. So there were other issues we looked at as well, but I would say those were the top three on which we spent most of our time. So.
Thank you, Rebecca. JG.
Okay, thank you very much for inviting me here. It's a long time since I visited Basel. For Korea, I think I need to go back a little bit to give you a little bit broader picture about what's going on in Korea. In addition to the CBDC project, what the Korean government is doing is to actually enact some law that will cover a security token. So we have both a CBDC project where central bank as well as the commercial banks are involved, and also the non-central bank and non-financial institutions, non-banks, involved in creation of a security token of underlying assets consisting of real assets, mostly real estate projects or some artworks, those kinds of assets that are not easily saleable or marketable to the public. The reason why I'm describing these two different projects is because Korea has a very unique legal environment. Unlike in the US where you have a common law system, Korea is based on the court system, and also it's a positive legal system where the financial institutions and non-financial institutions, they may be able to act only pursuant to the laws that are specifically provided. And therefore, the question about all these issues revolve around whether the financial institutions and central bank, the Bank of Korea, can engage in certain type of projects or services that are envisioned by these projects. So for the central bank CBDC project, which consists of issuing of e-money tokens and also tokenized deposits, and also connected to the outside the CBDC system, where there is going to be another set of tokens that are tied to, for example, carbon credit exchanges. So those are three different types of tokens that are planned under the CBDC project. And for the most immediate issue is whether under the existing laws, these types of tokens can be issued without amending any laws under the existing system. And for CBDCs, obviously, Bank of Korea has, under the Bank of Korea law, to issue the legal tender. The CBDC, the only difference of CBDC from the legal tender cash is just this digital form, and that doesn't require any amendment to the law. For the tokenized deposit also, the deposit can be issued by these commercial banks. It's in a different form, but that doesn't change the nature of the tokens as deposits, and therefore we did not think that the tokenized deposit by commercial banks would require changing any laws. For e-monies as well, there are certain specific laws that govern electronic financial transactions, and there are a lot of conditions relating to that, and therefore e-money tokens that are going to be issued by the financial institutions would need to be carefully reviewed by that. Currently, the Bank of Korea is focusing on the tokenized deposit by the commercial banks with some voucher functions. You know that the government is issuing some voucher to the residents, particularly during the COVID, and it cost a lot of money. And therefore, there is a programmability that is embedded into that, the token, and whether that's permissible and how that has a legal implication. So that was the first general point, whether there are any legal impediments under the existing law that these products can be issued. Now, for the tokenized deposit, there is one particular issue that is under. You probably know that Korea is very liquid market for general cryptocurrencies like Bitcoin and other crypto assets, and Korea is the probably most liquid market in the crypto assets outside the U.S. probably, and therefore there is a lot of concern about protection of consumers, and there has been a new law to protect the consumers of the crypto assets, and the definition in that law is very broad to cover a lot of digital assets. And the question is whether the tokenized deposit issued by the commercial banks would fall under the definition of the virtual assets in that law. And because in Korea, the financial regulation is regulated by the Financial Services Commission, and the issuance of the monetary policy is handled by the Bank of Korea. There is a segregation of the responsibilities, and the virtual asset is actually governed by the Financial Services Commission, and therefore there has to be some consultation between the two organizations as to whether this tokenized deposit will be exempt from the application of the virtual asset under this new law. And the solution to that is, without changing the law, the regulators and the central bank have agreed that they will process this through so-called regulatory sandbox, so that there doesn't need to be any actual changes into the law, but will give exemption from the application of law by applying the regulatory sandbox. So that's one area of the questions that we faced. The other one is that the privacy issue. Because this privacy law in Korea is very restrictive, and many of the transactions, if there is a identifiable information, for personal identifiable information, then that must be very carefully regulated. And therefore, if this unified ledger or central bank project, if there is a information sharing among different parties, under Korean privacy law, the sharing of information is, unless consented by the relevant individual, cannot be shared. And therefore, that's one issue that, that has to be continuously to discussed. And as the unified ledger becomes more developed, I'm sure that there will be some further agreement about cryptographic protection, etc. But so long as the so long as personal information can be identified through various sharing of information, then that's the big concern for the system. And finally, I think the issue of the interrelationship between the regulatory agencies and a central bank, how that responsibilities can be shared or allocated on the Korean system is very challenging. Because as I said earlier, the financial regulation is governed by the financial regulators, and the central bank is responsible for monetary policy. And this unified ledger is actually consisting of various issues combining these two organizations, and therefore the relative allocation of responsibilities between these two regulators and the central bank would be very important. And that has not been yet resolved, but for the tokenized deposit, at least this regulatory sandbox solution is one compromise that they came up with.
Thank you very much, JG. Rebecca, your top three legal issues, one of them was settlement finality, settlement and payment finality. And I guess, it's fair to say that the rules on these issues in most jurisdictions, were developed in a world where you could have a payments chain that would take days to complete.
Yep.
And I'd like to ask you and JG, how would the unified ledger innovations, like the ability to link payments through composability and programmability, or could it, or would it need to change the position with respect to settlement and payment finality? Would changes to the legal framework in this area be required, and what challenges would arise? And maybe, if you don't mind, I'll start with JG and then turn to you, Rebecca.
Okay. Right now, under the existing system, the there is a Korean law provision in the bankruptcy law that will make sure that the final settlement finality is guaranteed by the financial institutions. Now, we all know that the finality is an important issue because if once the payment instruction is given, some financial institutions goes bankrupt, and then this whole payment, because of the interconnectedness, if the payment is disrupted, then there is a large problem, and therefore we have a law that was adopted in 2005 that ensure that the finality of payment and settlement is guaranteed under the bankruptcy law. Now that is because there is the current system is a so-called deferred net payment system, where the banks are settling the net amount after the close of the day, even if the transactions happen during the day. So there is a delay of payment, and therefore there is a settlement risk, finality risk. So that is covered by this new law. Now, my view is that if we go on this unified ledger blockchain system, where everything is paid instantaneously and simultaneously, then I'm not sure that there is a real concern for finality because of this deferred net payment system. Because we are netting out, we are paying out on a basically gross payment system, an instantaneous system, so that maybe, Rebecca, you may have a different view, but in our view, this finality issue is not that apparent. One thing, however, I believe is more significant is if we use a smart contract, that might be a little bit different, because smart contract is a contract where you have automatic execution or implementation of the contract if certain conditions are satisfied. Now the question is whether your individual's payment instruction, which is based on certain satisfaction of certain conditions, is considered payment instruction now, or is it a payment instruction at the time of the satisfaction of the conditions? And depending upon how, I presume it is the latter, but depending on when exactly payment instruction is considered to have been made, I think the finality issue may be real issue, in my view. And therefore, I guess one thought is that maybe for the voucher system or some sort of government subsidy system where smart contract is used, there may be some mechanism to limit how often or what is the how many times or time limit of the uses of smart contracts or conditions in order to prevent abuse of the system by commercial banks under this finality protection under the bankruptcy code. That's my thought.
Yeah, it sounds like we do have a lot in common actually across our two systems. So we do have a finality statute in the U.S. We call it FIDISHA. It's an abbreviation, but it provides for the enforcement of the rules of a clearing system, notwithstanding the failure of one of its members, and notwithstanding any other state or federal law. That statute was adopted in the early 90s at a time when our settlement system, CHIPS at that time, also was an end-of-day net settlement. And so although it isn't preclusive of other systems, it's written specifically to protect net settlement systems. The definition of the systems that are protected by it has a reference to netting that may or may not, we think it does not limit coverage of the statute to systems that involve netting, but that question hasn't really been definitively answered. As a result, there's some question as to whether you have the protection of FIDISHA for any system that does not involve netting. Now, in most cases, with respect to if settlement is final before the point of that bankruptcy begins, I agree it should not be an issue, except we also have the distinction in the US of having something like 130 different insolvency statutes that theoretically could be relevant. We have insurance companies are liquidated or resolved under state law, so there's the 50 states for insurance companies. Banks are principally resolved under the Federal Deposit Insurance Act, but the organizing statute for a bank also affects its resolution. So there's the National Bank Act, and then there's the 50 state statutes as well. So even for CLS, we give the settlement finality opinion for CLS. Our opinion is something like 5 times as long as everybody else's because we have to go through all of the relevant regimes, and there's actually 2 other counsel that give opinions for Illinois and Massachusetts. So that'll give you an idea that it's a little different for us. So one of those regimes in particular, the National Bank Act, actually allows for the reversal of transactions that are final if they take place after, well, in contemplation of insolvency, and that can actually occur before the bank itself knows that it's failing. So now, there's exceptions to that, and it should not ultimately be a problem whether FIDISHA applies or not, but it makes it more complicated. And so if I had my druthers, I would have a new statute adopted that provided for finality of settlement systems regardless of whether it's a netting system or not, and regardless of whether the system's been designated. We don't think that's going to happen in the US anytime soon. And so, again, one of the reasons it's so helpful to have Article 4A apply is precisely to ensure that you have final settlement immediately. I am concerned about the smart contract issue you raise as well. I think that we would not view the transaction as final until the ownership of the funds has changed hands. And so if you've entered into a smart contract but it hasn't yet settled, you're going to have a question there as well. Another issue that may become relevant is that these systems are all going to have to be interoperable with all of the other settlement systems. And so in the US, we have different statutes determining when settlement is final for securities as opposed to cash. So we'll have to make sure that we can synchronize those 2 things when these systems become DVP. I think that's going to be possible, but we have to work that through. There's also the issue that if we're dealing with PVP and currencies on a system that operates actually using tokens as opposed to the way we've used tokens, but like ownership of the deposit is moved by moving the token, we may have to be concerned about whether you have finality of a transfer of a token. At this point in the US, we have a statute that solves, well, there's two problems really with tokens in the US. One of them is what law governs whether an asset like a deposit or an obligation like a deposit is actually successfully tethered to a token. The other is whether you can successfully show that you have a final transfer of a token from one person to another. We have a statute that's been drafted by the Uniform Law Commission, which generates the Uniform Commercial Code in the US, and they've proposed amendments to the Uniform Commercial Code that deal with that second question of when a token ownership has changed hands with finality. But it expressly carves out deposits from its coverage as well as securities for a couple of reasons. One, deposits are all already electronic, and there was a conclusion that you didn't really need new law to deal with what is already an electronic product. I think we will see whether that remains true. It was also out of deference to the regulators who are still working through their views as to whether you can, in fact, tokenize deposits and still be a deposit. I think if you look at the definition of deposits in most statutes, it doesn't refer to the particular computer system used to record the ownership of the deposit. But there is some anxiety around whether record-keeping requirements can be satisfied and whether the FDIC can get what it needs to get if it has to liquidate a bank that's involved in a system like this. And so there was a sense that it was just premature to deal with that in this statute. On the security side, again, there is a mechanism in place to deal with the electronic transfer of securities, but it doesn't contemplate blockchain specifically. Whether that's a problem, I think, is not yet known. I think that you ought to be able to fit into the existing statute, but there's actually an American Bar Association committee that's now digging into this. So there's a lot of efforts looking to see whether we'll be able to synchronize both across systems in the United States and between the United States and other systems.
Maybe turning to another question, which actually my colleague Morten Beck alluded to in his description of the plans for Project Agora, which is non-resident access to these different systems. As I understand it, both the RLN and the Korea project limit participation to domestic banks. And I'd like to ask you sort of what extra legal challenges would arise with the inclusion of non-resident banks in these systems.
So we did, RLN,
Go ahead.
so RLN limits settlement banks,
Yes.
the banks that can make central bank settlement to domestic banks. And that's driven by the restrictions on who is able to have a master account at the Federal Reserve. So I don't think that's something RLN can change, but that doesn't mean other banks can't participate and settle through correspondence, and the system contemplates that. What there is, though, is a restriction on the nature of the entities that can participate. So it's essentially limited to entities that are financial institutions for purposes of fiducia, that statute that I mentioned. The reason for that is this finality question. That means that it is limited to entities that are banks, broker-dealers, oh goodness, there's a list, but those are the principal participants. Commodity brokers, I think, are also included. It would not include e-money providers because we don't have e-money providers as a category in the United States. Well, we may, but we don't have a regulatory framework for them. And so they're not contemplated by fiducia. And it's another one of those things that one might fix if you were starting with a free hand.
Yeah, for this project, Bank of Korea obviously is limiting to the Korean commercial banks or foreign banks that have operations in Korea. If they were to allow banks outside Korea, which do not have operations in Korea, they need to change the internal regulations to allow that. And they need to have some sort of operating account, the current account with the Bank of Korea. And for that purpose, they need to change the internal regulations. And the reason for that is because they like to be able to monitor the actions of the banks that are outside Korea. And so that's one issue. And I think broadly, this foreign exchange the opening up the system to non-resident is a big issue in Korea because Korean currency is a non-reserve currency. It's not internationalized, and therefore all the settlement has to go through banking institutions through to Bank of Korea, and the Korean regulations actually protect or guarantee convertibility only for the Korean won currency that is residing in Korea. Any Korean won currency outside Korea is not protected or guaranteed for conversion by the Korean Central Bank. And therefore, there should be some mechanism, unless the Korean currency is really internationalized, which is not. And therefore, this non-residence issue, and particularly for the CBDC project, will have to resolve those convertibility issue and the FX regulatory concerns going forward. And I think the project Agora and some other projects that are mentioned during this summit would be a very helpful way toward achieve that objective.
Thank you. JG, maybe a follow-up in the few minutes we have left, but what about involving non-banks?
Non-banks.
Yes.
Non-banks can be involved. Actually, one of the project element which relates to e-money token to be issued by financial institutions envision non-banks to come into play later. For now, they are limiting it to central bank, the commercial banks, because of obviously various logistical concerns, and there are legal uncertainties about opening up these e-money tokens to non-bank financial institutions, and therefore initially the Bank of Korea is focusing on test piloting program only for the banks, but it will be extended further. But for that purpose, there are a lot of additional legal issues that have to be reviewed and consulted.
Thank you. We just have 2 minutes left, and maybe I can finish with a question for you, Rebecca. The legal report for the RLN PRC scoped out consideration of the organizational structure and responsibilities of the RLN FMI. Could you maybe briefly describe, some of the pros and cons of different types of structures that were considered?
So we thought about a number of different types of entities. I think some of the considerations are peculiar to the United States and go back to this question of whether there's a regulatory framework that's suitable for an FMI operating a system of this kind. I think we have a framework in the United States, the Bank Service Company Act, that gives the regulators the authority to supervise the provision of services by companies to regulated financial institutions. And that framework is fairly extensive and gives the regulators a significant amount of authority, but it does not give them the authority to regulate the capital levels of the entity providing the service or to provide consolidated supervision of the whole entity. And so I think there's been a thought that it might be better for a system that is likely to become systemically important, that it start from the beginning as an entity subject to overall prudential supervision and regulation. And that was why I think we talked in our report a little bit about the possibility of forming it as a banking type of entity that would operate the ledger. That said, this entity would not be holding any funds. All the funds will be held by the members, not by the operator, and it will be engaged principally in technology functions, unlike, say, a CLS. And so whether that's the best approach or not is something that would have to be worked out. I do think that the expectation is that being regulated as a systemically important financial market institution would probably make sense, and the question will be whether that's possible from the outset.
But you would have to have an entity that would be regulated.
Well, we don't have a system that says you have to be a regulated entity to operate a payment system. There are regulatory requirements that apply to different activities. We have state regulatory requirements for payment services providers under our Money Services Businesses Act, they're not really suited to this kind of wholesale service, and international service. They're really focused more on protecting consumers who are doing cross-border payments and remittances and other payments, although they apply to other kinds of payment services as well, crypto providers, PayPal, all the people involved in handling money who aren't essentially banks or otherwise exempt, speaking loosely. But they don't seem like the right framework for this. And I think, again, just given the significance, there was a sense that the participants would prefer that it be subject to regulation of this kind.
Thank you. I'm afraid we've run out of time, but I've been advised that there will be time for questions, but over a glass of champagne in the apero. So please join me in thanking our panelists for what was a fascinating discussion. Thank you.